A landmark court battle that started in Saskatchewan is heading to the Supreme Court. On Thursday, the top court decided to hear the provincial government's appeal in the school pronoun legal saga. The appeal centers on the province's preemptive use of the notwithstanding clause and whether courts can still review and rule on charter issues after the clause is invoked. The U of R Pride Centre launched the initial court challenge that led to the Supreme Court. Its lawyer says the government should have to defend its pronoun law with evidence.
If the government has made the unfortunate, I would say cowardly decision of invoking the notwithstanding clause rather than even seek to defend the constitutionality of its law in court, at least those young people still deserve an opportunity to convince a judge on the basis of evidence.
The government introduced the pronoun policy in 2023. The law requires parental consent for children aged 16 and under who want to use a different name or pronoun at school. The U of R Pride Centre argued the policy violates charter rights. The province then introduced the Parents' Bill of Rights using the notwithstanding clause. This rarely used measure lets governments override certain charter rights 4 or 5 years before it has to be renewed. In 2024, the court ruled in favor of U of R Pride and denied the province's request to toss the case. The government appealed, but in August, the Saskatchewan Court of Appeal ruled the U of R Pride challenge can continue. The government appealed again.
I haven't been briefed precisely on what the arguments are. However, it was their recommendation to appeal it to the Supreme Court. It's a decision then that we made on the advice of the legal counsel that we have, both in the Ministry of Justice as well as outside.
The pronoun law has remained in force during the legal battles. The Saskatchewan Teachers Federation says the pronoun law harms, not protects, children.
It places teachers in a really difficult position, and we continue to advocate for the government of Saskatchewan to repeal Bill 137 and ensure that teachers have that professional autonomy and the ability to use their professional judgment to be able to create a safe learning space for all students in Saskatchewan.
The Supreme Court has not yet set a date to hear Saskatchewan's appeal. Jeremy Warren, CBC News, Saskatoon.